Good evening, everybody. Welcome to Reasonable Doubt, presented by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, along with my co-host, Damon Parrish, and tonight we welcome two fellow criminal defense lawyers, Mark Bennett and Cynthia Henley, to the program tonight. We'll talk about a bunch of current events going on in the world today, but first we're going to talk about the flooding that happened in Houston this week. We're going to be with you all night long for the next hour, taking your calls. That was a little bit redundant, wasn't it? Not going to be with you all night. We're going to be with you for the next hour. We're going to be taking your questions on Twitter at HCCLA_TV. We're also going to be taking your phone calls starting around 8:30. 713-807-1794 is the number. We'll flash it up again at the 8:30 mark. So you can call in with your questions for Mark and Cynthia. And I want to start off with the Houston flooding, as I said. It's been a long week for everybody around here. We had a shutdown at the courthouse this week. The basement flooded. It's no big surprise with our criminal courthouse that we had a malfunction with high water. But I do want to thank everybody, because I think some of the stats that came out, our district clerk, Chris Daniel, did a great job of getting everybody organized, making sure that services got back online as quickly as possible. The judges did a great job of herding the masses in and out of the courthouses as best they could. And some of the stats that we had, they had 750 inmates, 235 pleas, 38 dismissals, and a bunch of other miscellaneous things that happened just yesterday. And guys, I don't know, I want to bring in all of my panel here today, co-host Damon Parrish, Cynthia Henley, Mark Bennett. I don't know how many of you guys participated in everything going on at the courthouse this week, but any observations that y'all saw?
You know, Cynthia actually spearheaded the defense side of that.
I know.
So because of Cynthia, we got it done. So thank you, Cynthia.
Well, I'm happy to help. It really wasn't about me. It was, you know, me posting something about what was going on down there. And one of the things I wanted to point out was, you know, while most of us, I think I'm the only one in our and I know Damon does appointments too in the misdemeanor courts, but what we recognize versus felonies versus misdemeanors is that it's days versus years or months. And so we had already had a long weekend, and we needed to go ahead and have somebody get in there and help some of these people. Just like I had one guy who was granted a PR bond, and he had been in custody since last Thursday. So that can't happen unless we're in court. But it was a madhouse yesterday down there. We had a big mess of people. That looks a lot better than it actually was.
And the hearings were moved, I think, to the juvenile center, weren't they?
Right.
We were in the juvenile center, and we also utilized the jury assembly room. So they bring the people over to the jury assembly room, and the lawyers would get the files, go over, meet with them there, then bring them over to that. That was a courtroom that we actually had two, a little tiny one and a bigger one, and they were trying to do it court by court in those two courtrooms. It went very well, and I have to say, everybody who participated worked hard, all the way from the staff, the prosecutors, the judges, and the defense lawyers who were there. It was really, it was a good thing to help get some of these people out of jail.
Public shaming works. You got them to do the right thing, and it's right for you to praise them now for having done the right thing.
Well, I don't know that it was just me. I just know that a bunch of people had things to say about me posting it on Facebook yesterday.
Well, I think
I was bothered.
The social media aspect of this really got the ball rolling. I mean, everybody's posting on Twitter, they're posting on Facebook. We're seeing long lines outside. I mean, everybody's getting active and trying to at least improve the situation down there. But something like this, where there's no court going on for 2 days and you've already had an extended holiday weekend. I mean, you've got people sitting in jail on domestic violence cases where they can't even get a bond set until they've seen a magistrate to get a no contact order.
I think they were still doing some probable cause over at the jail, which they can do the no contact there if they get arrested. But we ended up having 4 days in a row, and you know, sometimes if you're arrested on Wednesday or so the week before, you still don't end up on the docket. So you're talking days where some of these, you're talking a shoplifter, a little teenage shoplifter who doesn't have any phone numbers memorized of people to call her, and without pretrial services being able to interview them and talk to the judge to get the bonds approved, they sit in jail. So.
Well, I want to thank you, Cynthia, for spearheading it. And I want to thank everybody, the judges, all the defense lawyers who went down there, the prosecutors, for getting up there and making the resets happen and helping process this whole thing, because it's been a very trying time for everybody with the floods, and everybody's got their own personal situation too. So I'm sure getting down there was an enormous challenge for some people, and I'm just glad that we all came together and made it happen.
And I was talking about yesterday, today was bad too.
Yeah.
The lines that they picked, the pictures that they posted, and kudos to all the judges. I mean, I saw some things where people were saying that they were going to revoke bonds. I was in probably 4 or 5 misdemeanor courts, and they weren't revoking any bonds. And they were repeatedly calling the dockets all morning long, And if a lawyer called in and said, my client called, whatever, they were not being jerks about it. They really were being very fair, And that's all we can ask, right? Everybody trying to work together to be fair.
It's great when it happens.
Right.
It's notable when it happens.
It is.
We have something to talk about when common sense and fairness prevail at the criminal courthouse.
I agree.
Terrific.
I agree.
It's very true. Hopefully we don't have another event like that anytime soon that we have to deal with. But on to the topics of the show I want to get to tonight. And kind of the first thing is we like to cover some current events and talk about some things, and I like to get everybody's opinion on them. And the first one that happened this week, the big one, was the Cleveland police officer who was acquitted. He got onto a car and shot 49 times, fired into a car 49 times, went to trial, and was acquitted in a bench trial. Only a judge, there was no jury. Got the acquittal this week, and there was some unrest in Cleveland, not quite as much as in Baltimore or Ferguson as we've seen, but still some outrage, obviously, at the acquittal. And then, and here he is on our screen, Michael Brelo. He was the officer who was acquitted, and now the DOJ is investigating, and they've done their investigation on the civil side, and I think come to a settlement with the police office, the officers, and the department there as to some of the things that they need to implement. But I want
no more pistol whipping, right?
Yeah, no more. They have to agree not to pistol whip people. That's pretty amazing.
Well, they have the batons now. They don't need to use the pistol.
Right. But I want to get you guys' thoughts on the acquittal and kind of a little different process in that. I guess the state of Ohio doesn't have the right to a jury trial like we do down here in Texas.
Is that true?
That's what I understand from reading it.
Okay, I don't know. I don't know. It's either they don't have the right to, or
they waived it.
But they waived it. Well, why on earth would a prosecutor waive a jury trial when a
because they don't want the cop to be convicted.
Well, that's one of the things I want to ask you guys and get your opinion on is there was a congressional hearing the other day, and they had a hearing before Congress about some of these situations. And does there need to be some sort of mandate that we should get a special prosecutor involved when there are police officer shootings? Are the district attorneys in cities, are they too closely united with the police officers that they can't treat these guys fair or make rational decisions?
Unquestionably. They depend on the police unions for endorsements and for votes, and prosecutors and for that matter, elected judges are too closely tied in with the police to fairly judge those cases.
So do you think that prosecutions of police officers should go to a federal level, transfer to a federal court, or have some sort of federal
No, I think that in Texas that we ought to require special prosecutors when police officers are accused of committing crimes in the counties in which they ordinarily do their policing. So, for example, Harris County Sheriff's Officer was accused of murdering somebody. Well, bring in a special prosecutor. Make sure that everybody gets treated fairly.
And so the audience understands special prosecutor means like somebody outside the DA's office. It could be a defense lawyer. I know that Wendell Odom has been a special prosecutor, and some of the former prosecutors have been been special prosecutors. So it doesn't mean special, it just means someone outside of the office.
Well, and in this situation, it seems like the debate is whether or not somebody who is employed full-time as a prosecutor really is in a position of conflict to prosecute a police officer. And so to bring in, you can't really bring in the AG's office or a prosecutor from another county. You really do have to go the private attorney route, wouldn't you, if this is a solution that's workable?
Well, I suppose you technically could bring in the AG's office, since the AG's constitutional responsibility doesn't include prosecution.
True.
Well,
they're not really prosecutors. AG likes to pretend that they're all prosecutors, but they're not prosecutors. So they've got these little slices of prosecutorial responsibility, but I suppose that they probably don't work enough with cops that maybe they would be appropriate to prosecute the cops. But so the problem is not, I think, working with the cops. The problem is being on the same team day in and day out. And so if you take a respected criminal defense lawyer and make that respected criminal defense lawyer, Wendell Odom's an example, I think Kent Schaefer is a special prosecutor in a case right now, appoint that defense lawyer to investigate and prosecute the case, it's much harder for anybody to say, oh, it's the state covering up for the state. It's the appearance of impropriety that's being avoided if you have a special prosecutor in a case like that.
Well, and that's the rule. You're supposed to avoid the appearance of impropriety for like judges and things like that. It's not whether there's impropriety, it's the appearance. Because we want the citizens to feel like they're being respected and the process is right.
And I don't know that the rule that you have to avoid the appearance of impropriety applies to prosecutors or other lawyers.
The other thing I was going to say about the AG's office is they do prosecute. Like in smaller counties, when you have someone who doesn't have the ability to prosecute, say, a capital murder, they'll bring in someone from the AG's office to prosecute. But like Mark said, they don't have that special relationship. They have the skills, but not the special relationship, so that would work.
The AG's office has a couple of units that do specialized prosecutions at the request of the district attorneys, but they're not there every day. But still, I think that to the ordinary person, they see, oh, it's the state prosecuting, investigating the state or covering up for the state. It's the government covering for the government when you don't have a special prosecutor.
Well, there's certainly be a lot more respect.
What about the fact you mentioned the judge? In Texas, the judges are intertwined. Well, the perception that the judges are intertwined with the law enforcement. And I want to ask you this. I ask this because in the Bree case, the judge decided that Breelo was not guilty for several factors. One, that you couldn't determine out of the 100 bullets that the bullet shot by Officer Breelo is the one that killed the people. Two, he said that even after 100 shots were fired, the threat still may not have been over. So justified in shooting more. And three, he wasn't guilty of the lesser charge of felonious assault because it wasn't clear the threat was over. That seems weird to me. That you can't say out of 100 bullets, the one you shot may not have killed him, that 100 bullets is still not enough to solve a situation. Do you not think that there is some issues with local judges also being involved in a prosecution or against local law enforcement as well?
Sure.
So
didn't I say that?
Well, yeah, but then actually, wouldn't you then think it moved to a federal court or maybe change the venue altogether? So not Houston to Houston, but maybe Dallas and Houston.
Maybe a change of venue, maybe a visiting judge from a different part of the state.
Well, change of venue doesn't, all that does is change who your jurors are. Right. That's all that does.
Sure.
And those things that they pointed out, the three things you just pointed out, in Texas, I mean, at least you used to have the right to shoot and keep shooting. I don't know all the facts of that until it was the danger was over. And if you're involved in a shooting, it doesn't matter if your bullet is the one that kills or not. If you're involved in it and it's improper, that's what matters.
Right.
So I don't understand those 3 points. I mean,
that's what the judge found. Well, that was his ruling and why he found him not guilty.
If the feds do bring charges and they decide to bring whatever constitutional violations,
civil rights
violations, or some other criminal actions that they can find under the United States Code, I want y'all to put back on your defense lawyer caps for a second, because I mean I know as defense lawyers we're always adverse to police, and so the police conduct of itself, you're in a bit of a conflict sometimes watching this from the outside. But if this were your client and he comes in, he gets charged by the feds now, I mean it's all over CNN. You've now had a judge that's put out findings of fact and conclusions of law, basically, as to why an acquittal should be had. I mean, how much is your fear of retribution going before a federal jury now?
I don't know about.
I mean, how much?
I don't understand the question.
Well, I mean,
retribution by a
jury,
by a federal jury against a cop who shot someone.
Right. Now everybody's been able to read the judge's findings of fact and conclusions of law. They know, essentially, the case has been filleted out there in the open. You have a legal opinion, essentially, from a judge at the state level.
I think if I'm defending the case, that I want the federal jury to know about that ruling.
Right.
It's not that, I don't think that hurts my client. I think that helps my client, for the federal jury to hear that we've already gone through this once and the judge acquitted the guy.
Yeah, he's had a trial. I mean, that would be my position. And most people, even though we know that they can be tried in both state and federal court for the same offense, most people don't like that. They're like, you already had your trial. I mean, why should you have to go through it again? So that's one thing I would want to bring up repeatedly.
Do you think, from Damon's point of view, asking about the venue change, is that become more critical or less critical once you get into a federal court with this case?
Honestly, I don't know anything about venue change in federal court. Do you, Mark?
Very hard to get.
Never heard of a venue change in federal court. I mean, the jury panel's a lot broader in federal court. Right. So you're drawing not just from the county, but from the surrounding counties as well. And so if you're the defense, do you want to be do you want anything other than a jury in that district to decide the case? I don't see why you would. I guess I'd have to look more deeply into it, but just off the bat, I'd say, we've got this ruling from the local judge saying that the guy's acquitted, and we want people to know about that. We don't, we're not expecting the federal jury demographic, the conservative, older, employed, or retired white people. We're not really worried about them being a bad jury in that case.
Well, and on top of it, your judge that you're talking about, his ruling, he's elected.
Exactly.
Right. So he's popular. People liked him.
Yeah.
And so, I really want to get his opinion out there because they voted for him.
That would be my point of view.
So along the same vein, besides the obvious perceived bias the judge might be in your favor, what other reason might you try a criminal trial to a judge and not a jury?
Why would I?
All right, anyone. Besides the obvious perceived bias that he might like you, so he rule in your favor, is there any other reason why you might do that? A legal reason or any other reason why you might do that?
Well, I might do it if the publicity was so bad that I was worried that there would be a guilty verdict because of hatred or anger, and I thought that the facts actually were, while they may be bad legally, they may be in my favor. So he gave legal reasons, all right, whether I don't agree with them, but if I thought that the legality of it was in my favor, I would prefer to go to a judge.
We do have one of our viewers, Franklin Bynum, good friend of the show. He does say that prosecutors don't have to waive jury trials in many other places, and that the officers in Ohio actually did waive a jury. So
you mean
I tried finding on the statutes. I couldn't find where, similar to our statute, that the state does have a right to a jury trial. I couldn't find it in Ohio, but it's
so the prosecutors in Ohio waived a jury.
Yeah, that's what it sounds like.
So if you're defending, then if you think that the judge might acquit you on the law, then you might as well have a jury trial anyway, because the judge can still acquit you on the law, right? Can still give you a directed verdict. Why would I choose to do it if other than I thought I was going to win? Is that the question?
Right. Besides the perceived bias, is there any other reason to do that?
Well, no, because I think I'm going to win. I wouldn't do it unless I thought that a judge was going to give me a fairer break than a jury, because a jury is about as good as it's going to get. When you're trying a case to a jury, you only need one person to vote not guilty and stick with his guns to keep your client from being convicted. If you're going to a judge, you need everybody, that is one person, the judge, to acquit you, to keep you from being convicted.
Right.
Well,
On that same issue, I'll just tell you a different point. I picked a jury one time and had a motion to suppress that I thought was good, and I was very concerned that the judge would not grant it because we had already spent the time picking a jury. I know that's not how it's supposed to work, but I was extremely concerned about that, and I expressed that to the judge, so that's why I'm just saying a little different on the legality part.
Well, it's going to be an interesting case to watch. I know Damon and I will keep track of it and see what the next chapters hold. Now, I want to move to the next topic, and I think hell hath frozen over, ladies and gentlemen, because the conservative state of Nebraska yesterday abolished the death penalty. And I'm a bit shocked. I don't know about y'all, but to come from a Midwestern, very conservative state, and more than that, the legislature overrode the governor's veto and went against their very, very popular governor, too, up there. Went against him and by an over 2-to-1 margin abolished the death penalty. Is this a trend we can see? I know we had Catherine Case on a few weeks ago, and she said that support was waning for the death penalty. This may be the first domino to drop. What do y'all think?
I think that's true. I think it's just going to be a slow process, but I think that public sentiment in most of the country is becoming less authoritarian in lots of ways. I think that the people are becoming less pro-death penalty, they're becoming less pro-war on drugs, and I think we're going to see lots of slow societal changes, incremental changes, where things move slowly and then boom, something big happens, like one of the reddest states abolishing the death penalty. I think this is maybe not the first domino to drop, but it's an early domino.
Well, and I also think that people are really bothered by all the exonerations that have been going on, and nobody wants to really have that on their conscience. And if you've got life without parole, then there's really no reason other than financial to do a death penalty, in my opinion. I mean, I understand the argument that they could kill somebody in prison. I do understand that, but it's not like people in society, in free society, are at risk. So,
what about the argument that it should be at least kept on the books and that it should be still there for juries to decide, that the option should be available? There are those who argue that it should still be around. What's your response to that?
Well, Jimmy, I've heard that before, and I've never thought that the death penalty is a deterrent. I don't think I've ever heard of anyone saying, you know what, I'm not going to rob this person and kill him because I might get the death penalty later. I mean, I think it's facetious thinking to think that the death penalty has ever been a deterrent. It's only been a means of retribution and revenge, and I'm glad that Nebraska's gotten rid of it.
But here, more directly, here's the problem with that theory. The problem with that theory is death-qualified juries, right? That if you have a death penalty case where death is on the table, the jury has to be death-qualified. They have to be people who would be willing to give the death penalty in an appropriate case, which, as far as most jurors are concerned, that means a murder case, right? So if you have the majority of the people in the state who are opposed to the imposition of the death penalty, then if you still have the death penalty, those death-qualified jurors are going to be drawn from less than half the population of the state. So you've got something other than a fair representation of the population acting as the conscience of the population. You've got people who, by definition, don't agree with what most people think, making these decisions. So that's the logical problem with keeping the death penalty on the books if the voters are opposed to the death penalty.
Well, the other thing, just to point out to the viewers, is that there's an initial process where the DA's office makes a decision on whether they're even going to seek death. So it's not like the jurors are getting that choice in every case that could have death penalty. You know, it's one thing if the jurors always got to decide, but the DA's office is deciding first. And I'm not saying that's bad. I'm just saying if you're taking it away from the people in the first place, I don't see any reason not to take it away completely.
Yeah. It's a tough thing. I mean, I see the argument from those who want to keep it around and keep it on the books, but I have my personal feelings about it. I think we all do. How far away do you think Texas is from a move like this?
1,000 years.
Yeah, a long way, a very long way.
We do have made that exact same statement about Nebraska last year or 2 years ago.
Yeah.
Probably.
Yeah.
So do you think, in light of Nebraska, we are now closer than what you thought
No,
before?
still 1,000 years.
Yeah.
All right, so how about this? How about the fact that in the last 2 elections, we've had the major Mets, Houston, Dallas, San Antonio, be blue. And we've already seen that there's large Democrat. So now those.
I know what blue means. I'm just thinking about the last 2 elections, and I don't think you're right.
Yeah, I don't think that's right either.
Are you serious?
There's a
All our judges are Republican.
Sorry, presidential elections. I said that were presidential, 08 and 12. So during those times, for that elections, they were blue. And so there is a belief that Texas is no longer.
I might say purple. I don't know that I go all the way.
I said, but the major Mets, Texas may not be as red as it used to be, correct? I mean, not anymore. There's large influx of people from the north coming due for the oil jobs and everything. Texas is not as conservative as it was. So do you, in light of Nebraska, think or still believe that Texas is far away 1,000 years from the death penalty being abridged?
Maybe 996 years.
Well, you know, we used to be Democrat here.
Exactly.
I mean, when I've been practicing law, it used to be all Democrat judges, and we had the death penalty. So I don't know that that's necessary. This is Texas.
Right.
Rope them and hang them up high, okay? I don't see us getting rid of the death penalty soon.
So you think we'll be the last state to have it dropped?
Probably. You're close to
We'll be
it.
in competition with Mississippi, like we are for lots of things: education, healthcare, infant mortality.
Watch
lots
it
of
now.
things.
Let's just get down in the
I love
all
Texas.
right?
All right, watch it now. All right.
I want to quickly move to the next charge because this is Damon's favorite sport.
Football. You know I love it.
No, I want to move to the FIFA charges.
Exactly, football.
Yeah,
Football.
whatever,
Football.
whatever.
Football.
Is that
thing,
soccer?
Yes, man.
Yeah,
kidding,
that
I
thing
knew.
called soccer.
You can't tell I love soccer? Come on. This soccer body right here, come on. I love it.
Yeah,
So
he made me drive all the way to the soccer field to end up trying to drive.
I know, and now you get to talk about soccer, which I don't care about soccer. I really don't. But I find this interesting solely because the United States Department of Justice has decided to go after a lot of the top executives in FIFA, and I think that's the Federal Association of
International Football Association.
Football or something, whatever, soccer. Okay.
Right. Let's call it what it is.
The bottom line is they went after him with federal RICO charges, corruption, money laundering, stating that they used U.S. banks to launder all their bribery money in order to host these World Cup events, which are huge money makers, huge revenue makers for the countries that get them. And somehow the United States hasn't gotten one in almost 20 years, and they lost out on one to Russia and to Qatar. Right. Which apparently has brutally hot summers, and they're going to host a soccer tournament in 130-degree heat, but whatever. The fact is, they went in, they arrested all these guys in Switzerland, all foreign nationals, executives. They didn't charge the organization, and we have all the individuals they rounded up there on the screen. They're going to go through an extradition process. They're going to bring these guys back here, ostensibly put them to trial in the U.S. For money laundering, RICO.
For a whole lot of who cares.
Yeah, a laundry list of who cares.
Right.
What is the federal interest in prosecuting foreign nationals about a bunch of soccer games? I don't get it.
Well, I'd first like to say that's pretty funny that they're sending their money to our banks. I thought all our criminals sent our money to
Switzerland.
Sure.
What?
I mean, that's
What's
a good
up
point.
with
Actually,
that?
I don't know, right? Maybe they don't know. Maybe they just don't know. They're not
They do
smart.
now.
They know now. They're like, we should have did it correctly. You know, Jimmy, I think you said it. I think it's silly. I think this is one retribution for United States not getting the World Cup. In 2018, Russia got it, and now 2022, Qatar got it. And I think we wanted it, and we didn't get it, and we're sore losers. I think just like we had Rusty Hardenall talking about Roger Clemens and that fiasco, I think it's silly and a waste of time for the United States to spend any time, energy, or money investigating this. And this was actually prolonged. It's going on for a long time. It's been at least, I want to say 8 months, a year plus in the works. I mean, for soccer. I mean, it's really
Okay, I think Damon's worried that the soccer games are going to get screwed up.
I think he is.
I like soccer.
Well, that's what I'm saying.
All the goals and the running back and forth and all that stuff.
And the crying and the acting and all that kind of stuff.
Soccer's great.
And
the
then
cardio.
this buffoon IRS agent gets up at the public announcement and says, you know, this was the World Cup of frauds, and we just gave FIFA a red card. I mean,
That's like an SNL skit.
I kind of like that.
it was so stupid.
I like the word buffoon, too.
He is. It's so cartoonish. I mean, these guys are going to spend all this money to extradite
Jimmy
these
likes
people over
audits.
here. Huh?
I said Jimmy likes audits.
I do.
Oh, not me. I love the IRS.
Well, you know, please.
How dare you call our overlords buffoons?
I guess they'll watch it on YouTube, and then my accounts will be frozen or something.
I'll red card you, sir.
Yeah, exactly.
Right. So a Qatari guy bribes an Ivorian guy in Switzerland, and the money happens to go through a U.S. bank.
And this goes on in several cases. I mean, the FCPA cases, the bribery cases, where people are trying to get oil contracts. Am I missing something here? I mean, just what's the interest in prosecuting this?
I don't know, and frankly, it's the way that business is done in most of the world. Little taste here, a little bribe there, and I think that America's interest in prosecuting, you mentioned FCPA cases, is, well, we're Americans and we don't do that, and
that's
we want to
make practices.
And we want to make sure that the rest of the world doesn't do it either. It's not practical. It's not real to say we can prosecute everybody in the world who engages in business practices that we think are corrupt. Because what we think is corrupt is just ordinary way of doing business in most of the world.
Well, how about this question? Does that mean that that Americans are now going to be in danger when they go visit these countries?
That's the other question. I kind of wonder about this, because there's been so many cases involving the extradition of foreign nationals on fraud charges. And a lot of our treaties that we have, like for instance Switzerland and Trinidad, where these gentlemen were arrested, they won't extradite for purely monetary reasons. Now, I think Switzerland has kind of made an exception here because there's been some cooperation. I don't think they would have arrested them had there not been cooperation on the front end. But, you know, it seems to me like, why are we going after this stuff for, you know, money offenses and possibly putting more Americans at risk when they travel to foreign countries?
Makes us look like bullies.
It does.
You know, I think that the world generally recognizes the difference between Americans and the American government. I think that the danger that Americans might be targeted because of some stupid bullshit, some stupid stuff that our government does.
Red flag.
Red
flag.
We don't have a dump button. We don't have a dump button.
Is overhyped. I've traveled a lot. I've lived overseas, and even in countries that America perceives as being the enemy, I think people like Americans just, you know, we're like little guys.
Well, except for the psychos who are over there.
Oh, sure, but there are psychos everywhere. There are psychos.
It gives them a reason. I'm just saying.
So I have a question. I'm not as federally initiated as you guys are. I don't understand how we have a jurisdiction in the first place. I mean, if, let's say, the bribery and all the communications and everything took place on foreign soil, and this money just happened to swing through an American bank, is that enough to give American government
jurisdiction?
All you need is one little tiny thing.
Oh, wow.
Yeah.
And what if then the crime itself isn't a crime and where it took place? So
that goes to the extradition issue, and that's going
Right.
to be to me the interesting thing to watch is if they get the extradition from Switzerland, which historically has not extradited people on financial fraud cases back to America. If they get that on the front end, I think it makes it even look more like a political undertones type of case. And then when they get here, if they're going to agree to bond, if they're going to detain them, what are they going to do with these guys who, because there's going to be a presumption, as we talked about.
Stick them in Joe Corley.
Right, or the New York Metropolitan Detention Center right there on the southern tip of Manhattan.
On the
Are you
next
going to
point,
put them in the tent city? Is that what you're talking
it's
about?
the opposite true. If I do something legal in the United States and my dollar happens to pass through a bank in Qatar, am I subject to Qatar for extradition as well?
So the general rule on extradition is that a country will not extradite for something that's not a crime in that country.
What they call dual criminality.
Okay. So if you do something in the U.S. and it's a crime in Qatar and the Qataris want to extradite you, the U.S. will not extradite you. But let's say you travel to Mexico and Qatar knows you're in Mexico and gets the Mexican government to arrest you for something that's a crime in Mexico and in Qatar but not in the U.S. Well, it's not up to the U.S. whether you get extradited then, it's up to Mexico.
Okay.
So people arrested in Switzerland may have committed their acts in Qatar or Côte d'Ivoire or wherever, and it may not have been a crime there, but then they may have landed somewhere where it could be a crime, and that subjects them to extradition to the U.S. or any other superpower that goes around the world pretending that it can enforce laws in the rest of the world.
Red flag.
I can't think
The
of
world police.
Red flag.
I can't think of any others, but there's
Well,
us.
quit investing in bad things in
Yeah.
other countries, Damon.
Why is it all about me? I like soccer. I like committing crimes in places. I mean, that's what it is.
I'm going to reset our show real quick. We've reached the halfway point. This is Reasonable Doubt. We're going to start taking your calls, 713-807-1794. Keep your comments and questions coming in on Twitter at HCCLA_TV. We're going to get to the phone lines right now because we do have a call coming in. Hello, welcome to Reasonable Doubt.
Hello, good show.
Thank you.
Any comments about the medical marijuana bill sitting on the governor's desk requiring a prescription, even though there's no apparatus set up for a doctor to prescribe or a place to fill it? Now, I understand the oil is already hitting the streets. Any predictions about this law? Is this the beginning of the end of the drug war? Thank you.
Thank you. Thank you. Guys, your thoughts on the medical marijuana bill pending?
One way to look at it is a false step. Okay, we'll pass this because it's not going to do any good, and it'll be a little sop to the people who want to decriminalize or to legalize marijuana. Another way is a chink in the armor, and I think a chink in the armor is the best way to look at it, to say, look, this is a start, and it may not do any good to people now, but getting used to the idea that marijuana is a medical necessity to a lot of people will, I think, open the door to eventual legalization or even decriminalization.
Yeah, I think it's a big step, actually. I'm surprised that it's sitting there. So it'd be good.
Do you think it'll remain sitting there, or do you think it'll get signed?
I don't think it'll get signed.
They'll tack it on as a rider on the
And I also think that, if if any law got passed, they'd veto it. So.
And if they don't, then we can agree that Texas is even closer to abolishing the death penalty.
Well, I want to move to the real reason we brought you guys on here tonight, the fun stuff. Because Mark Bennett, you have been, well, how should I put this? A crusader
killer.
Yes.
in the statute killing of some of these unconstitutional online solicitation, online communications, online impersonations.
We all have hobbies, Jimmy.
I know.
Oh, that's
Some
sad.
people like to hunt big game. You like to hunt unconstitutional statutes.
That's right.
And you're going big time.
There's plenty of game for me.
There is. There seems to be a treasure trove of it all around this country.
Thank you, Texas legislators.
The first one that you got, that I know of anyway, was in 2013. You got the online solicitation of a minor statute knocked out.
Half of it.
Half of it. Yeah. Tell us a little bit about the argument, the statute itself, and what you used to really give it the death penalty, so to speak.
So the online solicitation of a minor statute had two parts. One was talking dirty to minors. The other was soliciting people who represented themselves to be minors to have sex. The first part is what I got held unconstitutional in the Lowe case because we have a constitutional right to talk dirty to minors.
What do you mean in a Lowe case?
The name of the defendant was Mr. Lowe. Okay. So I call the case the Lowe case. So that was the first part of it. And the tool that I used was the First Amendment. And the First Amendment says that we have free speech. And the law is that if a statute infringes on that and restricts speech based on its content, then it is unconstitutional unless the state can show that some exception applies. So that was the Lowe case. I convinced the court that the statute was a content-based restriction on speech, and so it was presumed to be unconstitutional, and the state couldn't show that any exception applied.
What court did you do that in?
This was the Texas Court of Criminal Appeals, which is probably the most conservative court in the
country. And where did you start? It was in Harris County?
Started in Harris County in the 248th District Court, and the 248th District Court denied relief, went to the First Court of Appeals. The First Court of Appeals affirmed the 248th, and then went to the Court of Criminal Appeals, where the unanimous court reversed the First Court of Appeals.
Meaning that you won at the high-level court.
I lost below and then won up high. Okay. Which is better than the other way around.
Absolutely.
So, Mark, doesn't the state have an interest in protecting some speech directed towards children?
Certainly. Certainly. The state has an interest, and this is Supreme Court case law here. This is not Bennett case law. The state has an interest in protecting children from solicitation, where adults are actually trying to meet up with kids for sex. The state has an interest in protecting kids from obscenity, from things that are harmful to children, and then the other protections that adults have as well, defamation, fraud, for example. There are about 9 categories of unprotected speech. And so the state has an interest in protecting kids from these categories of speech that is not constitutionally privileged. The problem was that the statute was overbroad and covered a lot more than obscenity. It covered a lot more than solicitation. And that's the problem with the second half of the statute is it's called online solicitation, but it actually forbids fantasy talk. It forbids a lot more than just solicitation of children.
And really it doesn't speak to whether or not this is morally reprehensible or shouldn't be done. This is more of a legal argument, a technical argument of what the Constitution calls for and what the First Amendment calls for. I want to make that clear.
Okay. Yes, no, absolutely.
Because I think we can all agree that it's probably not a good idea to talk dirty to minors, right?
Yeah.
We're all parents. Yeah. None of us want that to happen.
So we talked about this at the Court of Criminal Appeals. Yeah. The judges said, well, what are we supposed to do to protect our kids from this? Don't we want to protect our kids from this? I said, certainly. And as adults, as parents, we should keep track of what our kids are doing online. It's not the government's job. And that was the conservative argument for abolishing the statute is this is not the government's job, this is parents' job. And government shouldn't be trying to do parents' job.
Mark, when a statute's overbroad, though, isn't there something that the state or the legislature can do about that to fix it?
Sure, possibly. And actually the legislature has passed a new online solicitation statute which fixes the problems with the statute. The thing is that when they narrow the statute, they make it harder to prosecute. Okay. So the broader it is, the easier it is to prosecute. The easier it is to prosecute, the broader it is, which is fine. If the legislature goes back and narrows how it makes it more difficult to prosecute in the name of the First Amendment, I'm happy with that.
And meaning making it more difficult to prosecute, meaning it's more specific. If a regular person is doing something, they know that they're doing wrong. It's not that it's just so much that you can't know, can't understand.
Yes.
So then, Mark, give me an example of what under the current old statute, what was being charged and was unconstitutional versus what you believe now would be constitutionally allowed with the new statute.
So what was being charged is not really something I can address. I don't know that the statute was being applied in an overbroad way. The challenge to the attack on the statute was that it was written overbroad so that prosecutors could use it in an overbroad way.
So tell him applied versus...
Right.
Okay, so a defendant who let's say shares Miley Cyrus's Wrecking Ball video with a child could have been prosecuted under the statute.
Okay.
Because it's sexually explicit under the very broad terms of the statute, and it could be construed as being intended to arouse or gratify the sexual desire of any person. So sharing something with somebody online with the intent to arouse or gratify the sexual desire of any person was a felony. So that's an example, is sharing something titillating with somebody who is underage.
Okay.
Could have been prosecuted as a felony. Now what as of next year will be prosecutable is sharing sexually explicit material with the intent that the minor engage in sex with the adult. So with the intent that a crime be, that a real world crime be committed.
All right.
Okay, and that's fair game. That's incitement or solicitation of a crime, where the government is saying you can't engage in speech that is intended to result in a child being the victim of a sex assault.
So you said the new statute goes into effect next year?
I think it's January 1st. It may be September 1st.
So what's happening now? Is there just a moratorium? What's happening on it?
So right now, Section 33.021C, which is styled online solicitation but also covers fantasy, is still the law. So people are being prosecuted under 33.021C. I've got attacks in several courts of appeals on that part of the statute as well. And if I am successful in killing that part of the statute, then the people who were convicted under that part of the statute are going to get out from under their convictions, get off of sex offender registration. I've already gotten a bunch of people, 100 maybe, off of sex offender registration for violating 33.021B. There are a couple of hundred left, but there are a lot more people who are in prison or on probation or registering as sex offenders for violating the part of the statute that I'm attacking now.
And I want to put you on pause there because you said you got them off of the sexual registration list.
Right.
Talk about for a moment, because I want to know how impossible and how difficult is it once you've gotten something like this for somebody to get them off of that list? I mean, what kind of steps do you have to go through to get them off of that list? Is it very time consuming?
Ever off the list?
Yeah.
So they are actually off the list. It's very easy once you have the conviction overturned because the statute was unconstitutional to get them off of the DPS list.
So you understand what Mark is saying is that every case where somebody got convicted on this statute that Mark got overturned or got, found to be unlawful, all those people had to go back and attack. They didn't automatically.
They did not automatically.
Right.
So each one of them had
That's a good point,
to get a lawyer to go back. And I didn't do all of them myself, but I've heard from lawyers all over the state who have used the opinion in Lowe to reopen defendants' cases. But yeah, they all had to get lawyers. They had to spend money. They had to spend time to get their convictions undone.
And does it matter if part of their plea they waive their right to appeal?
No, not when it's unconstitutional.
Does not matter. Right. So a bunch of people were able to do this, and then once they had the case reopened because of the unconstitutionality of the statute, it was just a matter of explaining this to DPS, and they were off of DPS's sex offender registry. But there are lots of private websites that republish the DPS information, and getting them off of those lists is a different matter, and we're not quite sure how we're going to proceed on that. It may not be possible.
And anybody jump in on this one, because what about for people who are out of state? I mean, for instance, somebody who was in New Mexico and solicited a minor online, or was alleged to have solicited a minor online here in Texas, was brought here to Texas, was charged in Texas, convicted or placed on deferred adjudication, whatever it was, for online solicitation. They're now in New Mexico.
Had a guy from Oklahoma with that situation, sent a copy of the judgment undoing the conviction to the Oklahoma sex offender registry people, and got it off the list.
But again, it's them spending more money and more time and going back to fix something. When a statute is found unconstitutional, just like some of these drug cases where they've gone back and found it really wasn't drugs, and the DA's office really did step up and give notice to people about that, but you would think that there would be some kind of mechanism in there to fix it.
Well, and why is there not, and Cynthia, maybe you can help me with this, but why is there not an automatic expunction, removal, when you've been convicted of an unconstitutional statute? Why isn't there a mechanism by which these procedures are put in place to remove that from your record?
Suppose that you are charged with sexual assault of a child, and you plea bargain it down to online solicitation of a child. Do you want to go back and reopen that case?
That's okay, Mark. That's a really good point.
You may not want to. Because if you do, then the state can still recharge you with the
Sexual
assault.
Yeah.
Well,
Okay,
that's
possibly.
But that's a good point, but that's a very narrow tailored issue right there. I mean, can't you still have the same mechanism but give the defendant the right to pursue it or not?
Well, but that's what we have now. I mean, that's the defendant goes forward.
Well, now we have it where the defendant has to be in the driver's seat. Defendant's got to go and say, hey, I got to hire a lawyer, I got to file the appeal or whatever, and do what I have to do. Can't you still have the mechanism where the state comes to you and says, hey, this can be overturned, but XYZ can happen or not?
You're still going to need a lawyer to help you make
Well,
the
always.
decision. It's a very specialized decision to make, and I've had lots of people who've jumped one way or another based on my advice after I'll get the file from the DA's office, I'll get the file from the prior lawyer, and I'll see what the chances really look like if they get charged with something else. Some of them have no exposure to anything else, a bunch of them do.
So let's take it another
That
step.
does make sense.
So they're going to need a lawyer anyway. They're going to need to hire somebody anyway.
Okay, so starting January 1st, we now have a new law in the books that covers what was once unconstitutional and now constitutional.
Right.
Can somebody be charged after January 1st for acts committed before if they were charged before as well?
No.
Okay.
No, because it's a new law, and the ex post facto clause of the U.S. Constitution would bar prosecution of people who committed their acts before the law was effective.
You know, what would be nice, though, is just like the DA's office now, when they get these tests back and it's not drugs, especially on the misdemeanor cases, because they are going ahead and pleading cases, they send notice to the lawyer that this happened. So, you know, it's not that hard for them to compile these lists to at least send a letter to the lawyer, because unfortunately, too many lawyers don't know the law and don't keep up.
Harris County and Fort Bend County sent notice to the defendants. I don't know if they sent notice to the trial
They did
plea
not.
lawyers
I
as
can-
well.
I
But see, and I'm a little bothered by that. Why are they contacting a defendant when the defendant had a lawyer? Why did they go around the lawyer and go directly to the defendant?
Especially when the defendant may not have the same residence, but most likely the lawyer has had the same location, telephone, fax number for a long time.
Well, plus defendants, I mean, they're defendants, okay? They didn't understand what they got or whatever,
Probably
you know what I'm
hoping the
saying?
letters
I
would get
still don't
lost.
understand why not go through the lawyer.
And I sent a bunch of letters to people at the addresses on the sex offender registry, and out of 200 and some letters, probably 20 of them have come back with bad addresses on the sex offender registry,
Yeah, that's not good.
which is a problem with the sex offender registry.
So
That
so
begs
Mark,
a whole nother.
You know what, that was good of you to do that, Mark. That was really good of you to do that.
I'm not doing it entirely pro bono.
I understand that, but still, that was good of you to take that initiative and get it out there, because it's getting the information to the people who need it.
And when I kill my next one, I will suggest to the DA's office that they give notice to the lawyers as well as to the clients.
Speaking of killing your next one, you got partially killed last week. This online impersonation statute.
Right.
Right here in Harris County.
That was in the trial court. I
Right.
won in the trial court, which was good. It was Judge McSpadden who was able to actually set aside politics, as he tends to do, and look at what the law said. So the state has promised me that they're going to appeal that case, and so I'll go up to the Court of Appeals as the appellee, which is an advantageous position to have, because I just have to respond to them.
The burden's on the state.
Is this
As
the
it should
first? Is this the first attack on the online impersonation statute that you have?
Yes.
Okay. So we're not looking at any others that are going to go up before this one.
Well, actually, no. I argued one in the Dallas Court of Appeals on Tuesday, and there's a jurisdictional issue there, too. What I mean is that the Court of Appeals is not necessarily going to get to the question of the constitutionality of the statute, because it's a juvenile habeas, and the Court of Appeals doesn't know whether they can actually decide the issue.
One of our viewers on Twitter asks, can someone recover probation fees, fines, and court costs if they were convicted under a now overturned statute?
Probably not.
Yes.
yes,
There-
you can.
Really?
There is a statute that calls for a motion to correct court costs.
Really?
And I got my third check for a client today from the probation department. There are two theories. One is that everything that the defendant pays to the probation department has to pay back. The other theory is that the probation department only has to pay back what the probation department kept, and we have to go after the people who the probation department passed the money on to.
Well, that was what I was, yeah,
Right.
that's what I was concerned.
And I've got a split of opinions among judges in Harris County. A couple of them think that it should go one way, and a couple of them think that it should go the other way. Obviously, probation thinks they should only be responsible for what they ultimately kept, but they collected it. They're in the best position to get it back and return it. So yes, and we're talking thousands of dollars. Unfortunately, we're not talking tens of thousands of dollars, which is what we would be talking about if we included polygraph fees and sex offender counseling fees.
Right.
That's a different challenge. And we're not talking hundreds of thousands of dollars, which is what we would be talking about if we included lawyer fees, lost time from work, lost job opportunities because of having been prosecuted under.
Well, what about incarceration?
Statute.
What about just if if I'm exonerated, I can get money back potentially? Can you get the same thing if it's over unconstitutional?
Open question. The Court of Criminal Appeals is considering it now. The issue was briefed at the beginning of the year, and so I'm hoping sometime soon we'll get a ruling from the Court of Criminal Appeals on whether somebody who was prosecuted under an unconstitutional statute and then the conviction was reversed, whether that person is actually innocent for purposes of the exoneration.
Boy, you just think about all the worms that opens up. When you have a statute found unconstitutional, and who's responsible for it, and where are you going to go, and who are you going to get the money from, and whose fault is it? It's different when there's been a conviction and it was overturned and a jury just made a mistake or whatever. Okay, but with this, it seems like the legislature is ultimately responsible for everything.
The legislature ought to be opening up its pocketbooks. And I went out there to testify against some other statutes this year, and they're going to pass, and I expect that 2 years from now I'll be able to go back there and say, hey, I told you so.
Well, see, now that's very interesting too, because if they're on notice that there's something wrong with them, and then they pass them anyway.
Unfortunately, we don't have personal liability for legislators.
I know, but you just think about it from the taxpayer's point of view, because that's where all the money ultimately comes from.
Absolutely. I know.
Well, Cynthia, I know you wanted us to use the last portion of the show to let everybody know you're single and ready to mingle. Have us help you out on dating and get you hooked up on Tinder and everything. But we're going to get you kind of close. We're going to talk about these revenge porn statutes.
Do you know I just actually turned red, and I don't ever do that.
on revenge porn or Tinder? Which one is it?
So
yeah, we're going to talk about revenge porn.
We're going to talk about revenge porn is what I want to get into, because there's this new movement, and I know, Mark, this is another area you've been hotly debating people on social media about these revenge porn statutes. There's a lot of civil lawsuits that's been going on with regard to them. And I want to talk about the latest story that came out just last week, where a former New York Jets linebacker pled guilty in New Jersey to their revenge porn statute. And he was posting pictures of his ex-girlfriend on Instagram. And from what I can understand in reading the news, they weren't exactly the most racy pictures, but they were enough to qualify under this New Jersey revenge porn statute. I want to get your thoughts on the revenge porn movement, if you will, in general. And from your perspective, Mark, are these statutes going to survive?
No. No, I've looked at the New Jersey statute in particular, and that should have been subjected to a pretrial attack based on its unconstitutionality. I think it's proof that celebrities don't necessarily get the best representation. That statute should have been attacked, and when it eventually is attacked, I expect that it will be held unconstitutional.
Well, Mark, so if I have sex with someone and we later break up,
right,
and then we made a video, we consented between us, but we only consented between us, right, and then he posts it somewhere, so I'm just SOL?
This is what we're waiting for, ladies and gentlemen.
Right.
Here we go.
So there's civil liability, and Harris County juries have held people who do such things civilly liable, as they should, but no criminal liability. The reason there's no criminal liability is that there's nothing about that posting of the pictures that takes the speech out of constitutional protection.
But what about an invasion of privacy rights? If we make a video or pictures in our bedroom that I intend just for you and you for me, and you put it on the internet, haven't you invaded my privacy?
Mark and Damon?
Right. So
the video is not out yet. It's not out yet.
And I do not
that opens up a whole nother
I do
Tinder
not
right there.
consent to you revealing that video, Damon.
I know a good lawyer who will get me off in more ways than one.
No pun intended there. No pun intended there.
Right. So the Supreme Court has never recognized violation of privacy as an exception to the First Amendment, and I doubt that the Supreme Court ever will.
But what about revenge porn, not as a violation of First Amendment, but a violation of my right to privacy? So I don't sue under First Amendment, just right to privacy.
You wouldn't be suing under the First Amendment. You would, or prosecuting under. So some of the proponents of revenge porn criminalization think that criminal law is the same as civil law for purposes of the First Amendment. It's not.
Right.
Okay, so there are things that you can't do in civil law there are things you can't do in criminal law that you can do with civil law. You can sue people for things that you can't prosecute them for.
Yeah, but well, what am I going to get money for? What is the civil recoup?
What is the
what's my loss?
So there are breach of privacy torts, there are intentional infliction of emotional distress torts, and revenge porn, strictly construed as revenge, is intentional infliction of emotional distress. People are posting these images not just to...
Why is it not harassment?
How would it be harassment?
Well, to post something that puts my face out there and puts my privacy out there, why is that not harassment?
Well, it's not covered by a criminal harassment statute that I know of.
But could...
But yeah, there are a bunch of possible theories of liability. A lawyer named Joseph Matthew got a big verdict from a Harris County jury based on his client's images having been exposed to the public by an ex-boyfriend. And I don't know the civil theories. I just know that there are civil theories that work, that have worked, and that pass constitutional muster.
Well, I was just thinking of the criminal harassment statute.
I don't think the criminal harassment statute is written to cover that.
Right. Okay, I agree with that.
Right.
But can they change that to add that?
So,
But isn't this kind of the same thing when somebody hacks into, for instance, all these celebrities? I mean, they have no recourse criminally if somebody hacks into their phone or hacks into their account.
Sure,
yeah, they
do.
do.
There's no actual revenge. If there's a hack, then that falls under the wiretap acts. Okay.
Right.
Now it would be a different situation if somebody takes it off of your phone, or if a boyfriend goes in and gets it off of your phone.
Or a police officer sends
that would
it
be
to
different.
himself.
But I mean, just if a celebrity is hacked, that opens up a whole, or if you're hacked or it's stolen off your phone, that opens up something, I think. But I mean, I'm kind of with Mark that there's nothing criminal about taking a picture.
That's because y'all are
consensually
both married. Y'all don't understand.
well, no, maybe
I'm married.
And he's married too.
But I understand.
maybe there should be something criminal about it, but there can't be in keeping with the U.S. Constitution. And the distinction that I would draw between the harassment statutes and any proposed revenge porn statute is that harassment statutes generally are not content-based. You don't have to look at the content of the communication to decide if it was harassment or not. Somebody makes your phone ring repeatedly.
With intent to harass or annoy.
Right. Phone ringing repeatedly, it doesn't matter what the person is saying if the intent is to harass or annoy. Somebody calls you repeatedly and doesn't say anything. It doesn't matter what the content is. There's no content. It's just calling you. So that's not a content-based restriction on speech. Revenge porn has this element of nudity or sex, showing somebody's nude body or sex, sexy poses or somebody having sex. And so that's content-based.
So how come? So they could make it. You posted on a public source photos of me with intent to harass or annoy me.
Except that photos of you is still content-based because you have to look at the photos to determine whether they're photos of you or of your dog.
But the calls are, in that sense, content-based because they have to be coming from your phone. I mean, I understand content, it's not exactly.
Yeah, well, it's really a pretty strong distinction between having to look at the content and just looking at the manner.
Guys, I'm going to have to interrupt the debate because we are out of time.
We're not done.
I know. We're
talking sex.
We're going to have to take it off air. Because we are out of time. So I want to thank both of y'all for coming on tonight.
After hours.
That's right. We're going to go to Reasonable Doubt after hours to talk about revenge porn.
We could talk about real stuff because it would be after 11.
So we want to thank everybody for sending us your questions on Twitter, sending us your comments, and also for calling in, the one person that called in tonight. Thank you very much. We'll be back next week with Lisa Falkenberg talking about her Pulitzer Prize-winning article for the Houston Chronicle. So we'll see y'all right back here next week. Thanks a bunch and good night.
Good night.